Now, many of us, whether you're a casual worker, contract worker, permanent staff member, many of us have questions and concerns as well as complaints around our conditions of employment at this time. Companies themselves also have questions about the rights and correct practices and procedures with regard to how to go about dealing with their employees. And then, of course, there are those who might try as employers to get away with not paying as they should. And joining us now to assist us to better understand at least some of the matters around employment is Imraan Mahomed, who is an employment and labor law specialist. Thank you so much for your time this morning. Welcome to Morning Live. Imraan, can you hear me?
I can. Can you hear me, Sakina?
I can hear you now. Thanks so much for speaking to us. Now, Imraan, let's just start with something as simple as perhaps domestic workers who may have been laid off, and what are their rights at this time?
Well, domestic workers who've been laid off can't necessarily be laid off, because the concept of layoff is quite a complex principle in our labor law. So there can't be a layoff without an agreement by a domestic worker, for instance. If there's been a layoff, well, there's a remedy under our law in order to refer that to the CCMA. So without consent, there can't be a layoff. That's just the general first principle. But if there's been a termination without a process, a dismissal of a domestic worker or any other worker without a process, that gives rise to a claim before the CCMA or a bargaining council.
Now, Imraan, what we are also hearing a lot of here at Morning Live is people saying that their companies are simply not paying them and they're not giving them any notice. It's you wake up one day and suddenly you're told you need to go and do an application to get some funds through the UIF because your company simply is not going to pay you. So what are the rights of both employer and employee at a time like this when there are many variables and uncertainties?
Well, on the first question regarding an employee who's been told that an employer can't pay and that the employee must then try and access funds through UIF, such sort of a position adopted by an employer is unlawful. There are directives that have been issued pursuant to the regulations under the Disaster Management Act by the Minister of Labour and Employment, which specifically provides that where a business is suffering an economic pressure as a consequence of the lockdown, is enabled under the directive to recourse from UIF through what's now popularly known as the TERS scheme. TERS benefits are not provided by UIF to individuals. It's got to be processed through an employer, and an employer is obliged to process those claims through TERS in UIF. So any employer that says to an employee that I cannot pay because of the lockdown, and that the employee is to fend for himself or herself or to go to UIF is acting unlawfully, and those sort of complaints can be referred directly to the Department of Labour.
So is that the only recourse available to employees, that they need to report this matter to the Department of Labour? Is there anything else that they could do?
Well, the other mechanism and the importance of trade unions is now becoming known to a number of employees, and the relevance of trade unions also to employers who now are seeing the benefits of being able to talk to organized labor as opposed to individual staff is also another mechanism. So trade unions, and I've seen it, are coming to the party more often than not in constructive manners in order to try and assist their members where there are difficulties. So the other mechanism is to speak to a union. I would suggest speaking to the CCMA or referring a claim to the CCMA, but the first port of call is actually the Department of Labour.
Imraan, what about companies who find themselves in distress right now, unilaterally deciding to cut the pay of employees by whatever percentage it may be? What does the law say about that?
Well, the legal position is that there can't be a reduction in remuneration of an employee without consent. That's the starting point in our law. Even in these exceptional circumstances, an employer cannot simply sidestep the law and go off to employees and say, because of financial distress, we are not paying or we are reducing payment. There's got to be a process of engagement with employees up until a point of consultation, up to the point of an agreement. If an employee refuses to agree on a reduction, which I must tell you, in my experience over the last 4 or 5 weeks in relation to these sort of matters, and especially dealing with trade unions, that is not likely. Even trade unions accept the precarious circumstances are willing to accept reduced salaries and the existence of businesses after this pandemic, as opposed to not having businesses return to business in due course. So to sum up, an employer cannot unilaterally not pay. An employer cannot unilaterally reduce a salary. It requires an agreement of an employee. And if the employee does not agree, then there are mechanisms in law in order that would give rise to potentially a redundancy and the like. But before you get to that, there's got to be a process of engagement with employees.
Imraan, now on to a specific case of someone who wrote to us, Rosalind, who says that she was employed permanently by Company A, left her employment to take up employment with Company B. And it just so happened that the start date of her employment at Company B coincided with the first period of lockdown. The new company then said to her, sit tight, we will start once the lockdown is lifted. You can start then. When the lockdown was then moved from level 5 to level 4, she got another message from the company saying to her that she has now been retrenched. And upon inquiring as to why, the company told her that they have decided to embark on Section 189 and are applying the last in, first out principle, and she was the last in, therefore first out. But she subsequently found that she's the only one who's been retrenched. So what are her rights in this instance?
Well, if she's already been retrenched, and that's my understanding of the question, that she's already been retrenched, it smacks to me of unfairness and a process that's actually unfair. And what your caller or the person on Twitter has put out, you should actually be referring a claim to the CCMA. So there's 30 days within which to refer a claim to the CCMA. It can be done online. There's new directives that have been issued by the CCMA of late over the last couple of days. She's got 30 days within which to refer that dispute, and she must do that as a matter of course to the CCMA. But a retrenchment without any process, simply issuing a notice to an employee and informing them without any process of consultation, even for an employee with one month's service, or she didn't actually even render any services, smacks of unfairness to me.
So what should she do? What recourse does she have? Where does she take this from here?
To the CCMA. So she's got 30 days from the date of termination to refer a claim to the CCMA. And the CCMA will now accept claims by email. There is a directive, like I've said to you a little earlier, that was issued by the CCMA late on Friday last week, that now provides that claims by employees can be made by email. She'd have to refer that claim to the CCMA, serve a copy of it on the employer, and the process will then run through the CCMA or a bargaining council if the employer falls within a bargaining council.
And just speaking to the CCMA, Imraan, one would imagine that they will be inundated with all sorts of cases that they will need to look at post this COVID-19 lockdown, because companies, as much as employees, have many questions about what to do at a time like this. Do you think that, you know, the fact that the CCMA itself may be inundated would also be prejudiced or prejudicial towards the rights of employees post this lockdown?
I don't believe so. So let me try to answer your questions somewhat differently. If you put aside post-lockdown, let's deal with what's currently happening. The CCMA must certainly be inundated currently with massive retrenchment sort of matters. So the law provides that the CCMA, during the course of what we've spoken to before, is consultation processes where there are large numbers of employees involved. that the CCMA can be called upon to assist both parties, both employers, both the employer, the affected employees, and a trade union in trying to consult and resolve the retrenchment process. So the CCMA, outside of its normal caseload, the normal stuff, what it would do in the ordinary course of business, would now be inundated with those sort of claims that are coming through the CCMA. So there must certainly be an uptick within the CCMA and pressure within that organization to try and resolve those sort of large-scale retrenchments, no doubt. There's certainly been a large uptick in relation to retrenchment contemplations on the part of employers over the last couple of weeks, and unfortunately that trend is going to continue as this lockdown persists over the next who knows how long. Then to your issue in relation to post the lockdown, the CCMA is obliged to continue and has already issued a directive providing a mechanism as to how it will continue during the course of the lockdown in order to continue to process claims as they now come out. So the CCMA has, whilst its offices may physically been shut down, it has historically been one of the organizations, one of the government agencies that have used technology quite steadily, very well. In fact, the director of the CCMA at a conference last year made the point that the CCMA was on a drive to become a lot more e-friendly, to become a lot more accessible to people on online platforms. And all kudos to the CCMA within its constrained budgets, that it has certainly done well pre the lockdown on those sort of platforms. And personally, I think it has the ability to continue on that trend, subject to having the available resources, obviously.
And then, Mohammed, with regard to things such as masks and other personal protective equipment, sanitizers, which employees are forced to wear, for example, in the instance of masks, whose responsibility is it to provide that? Should the company take that responsibility if indeed they expect you to come to work wearing a mask, or is that for the account of the employee personally?
Well, that's for the account of the employer. A directive was issued by the Department of Labour in the beginning of May, which specifically provides, it's actually law, that an employer is obliged to provide an employee with face masks. An employee is entitled to 2 face masks at the cost of the employer. PPE must also be provided by an employer in regard to its workplace circumstance. So doctors are a classic example, are entitled to better form PPE because of the exposure to the virus. An office worker who simply works in an office by himself or herself with very little contact to other individuals is entitled to a face mask, but wouldn't be entitled to other forms of PPE because of his or her exposure to the virus. So it depends on the circumstances, but the law requires a workplace return to work policy, and employees should be familiar with that. Like employers, they have an obligation to ensure that on their return to work, that the workplace is a safe and healthy environment.
And if the employee suspects that the workplace is indeed not a safe and healthy environment, do they have the right to refuse a return to work? And in that instance, what are the rights of the employer?
Well, an employee can't simply take a position that the workplace is not fit to return without a proper factual analysis of that. So an employee who's sitting at home, so let's take a permitted service under level 4, and an employer has now 12 days into May informed its employees that over the last 12 days it has taken all steps in order to have the workplace properly readied for a return to work. It's put in place the correct policies, mechanisms, and the like as directed by law. An employee who has not been at the workplace since the end of March then simply refuses to return to work, well, that's not satisfactory. Unless the employee or a trade union is in a position to identify specifically where the employer is not compliant with the law, well, It's not sufficient for an employee simply to say no. It's got to be based on fact. So let's deal with a situation where an employee raises a matter of fact and says that the workplace is not hygienic and that employees are going to be exposed to the virus. If that's a situation, and then an employee is obliged to deal with those complaints by an employee in order to ensure that the workplace is safe for workers to return back to service. An inability to do that creates liability under the Occupational Health and Safety Act, and employers can't expose the employees to an unsafe work environment. So there is an obligation to ensure that upon a return to work, that the work environment is readied in regard to what we currently face.
And just a final question, Imraan. Vigilantes, and we've had quite a lot of questions around UIF, and he says, UIF betrayed us. My company's application was successful 3 weeks ago, but no payment. It's better to go back to work than to have false hope, open up the economy. So a lot of questions around UIF and what's happening there, and I think you touched on this, but what happens in this instance?
Well, this person's complaint is directed to the wrong party. He's critical of UIF, but his complaint actually goes to his employer. So he says UIF made payment 3 weeks ago, but UIF is not assisting. But UIF has assisted. It's complied with its obligations under the law. It's made payment to the employer. Now the non-payment is at the instance of the employer. All the employee needs to do, and it must be accepted that in these exceptional circumstances, I'm certainly not a psychologist, but the pressure of this lockdown creates emotional stress for lots of people in different forms. And there's lots online that one can read about that. But this year appears to me to be one example of that. All this individual needs to do is to be rational about the situation. He has information that says payment was made by UIF to the company 3 weeks ago. It doesn't take more than simply writing a letter to the HR department to say, I'm aware that UIF made payment 3 weeks ago. I've not received my TERS benefit. And then to seek a response from the employer. So there's the short point of that is don't create conflict in circumstances where there is no reason for it. Be rational, engage with your employer. There may be a legitimate reason as to why payment was not made. There may or may not be. If there is, understand it, process the issue, and get back to work, because we've got to get this economy started or kick-started on some basis sooner rather than later. If the employer has not made payment on a rational basis, well, then lodge a complaint with the Department of Labour. The Department of Labour is going to and has an obligation or has the ability to run audits on employers who've received TERS benefits, and it will exercise its rights.
Well, Imraan, thanks so much for your time this morning and for the advice. Imraan Mahomed is an employment and labour law specialist discussing issues related to both the employee and employer during COVID-19.